daily cost list. Item number 1 for pronouncement of judgment.
I'll read only the operative portion. Viewed thus, the impugned judgment passed by the learned appellate court has been passed erroneously, and the same cannot be sustained and is hereby set aside and quashed. The appeal filed by the petitioner, appellant being criminal appeal so and so, before the learned additional deputy commissioner is restored to its number, and the same is directed to be heard and disposed of by the learned appellate court. Because you see, this court in revision cannot appreciate evidence.
Yes, my lord.
So, and you will be losing a forum if,
Absolutely.
if this court decide on the merits.
Yes.
Let it go back.
Let it go back. Obliged.
Yes.
I wish to mention you, Lucy, for digital accommodation today.
What case or number?
Item number 4. Four, 6 and 10.
Well, Mr. Devnath, why you are just delaying, like they say, delaying the inevitable.
Today, Lucy.
If you cannot, you see, apparently you can prove. So perhaps the the benefit of doubt will have to go to the petitioner.
Digital accommodation today, Lucy. I was not in a position to go through these citations because due to some.
Let me do one thing. Let me pass the judgment.
I come the next
You
week.
can always appeal. It makes no difference to you.
Next week, Lucy.
What else can you cannot improve your case.
I'm not improving, Lucy. Just asking some.
For what? Unless it is produced in black and white. Nothing can help you.
Next week, Lucy.
Well, more than we have filed the almost a month. Your Lordship has given time for filing of the citation. In as far as the
Last week
service is concerned, my lord. My senior is well aware of what citation is supposed to be filed. I have given him the copy also, my lord.
He has given the list. I have to go through. My left was not one.
He cannot improve his case on my list of documents, my lord.
Just to go through what's right.
Because it's a matter of facts, not even a matter of law.
My lord.
Last chance and no more. Accommodation has been sought for by the learned CGC in this matter. It is to be noted that this matter has travelled quite a while on this point, on the point that, on the ground of the respondent seeking either instructions or relevant authority or otherwise, which has not been forthcoming till date. Be that as it may, in deference to the prayer made, the same is allowed. It is made clear that no further adjournment will be allowed. 1 week or 2 weeks, up to you.
2 issues.
Last. Allow into a last no? This is matter for 2 weeks.
Obliged.
Item number 6.
Mr. Jha, you here? That list. Here also, it depends on whether you are entitled or not, and since the list is there.
My lord, list.
When your turn will come, we don't know.
My lord, the hurdle is that, my lord, they have whether that any policy has been, they have placed any to the ministry that revocation of that completed appointment. If that it is not revoked, my lord, the question of anyone appointing will not arise. So what are the
Oh,
steps?
that ban, you mean?
Yes, my lord, ban. So, my lord, there is that in that letter itself, it says that a proposal should go from the respondent that, okay, we will lift the ban.
Yes, I think there was a reference, some notification was there.
No, my lord,
They ban
for that
negative.
only, my lord, instruction was sought. What are the steps?
But you have made a proposal to the ministry for
Your Lordship,
revocation of the ban.
In this matter, Your Lordship, I was short from this department, any instruction, so not yet I have this one. Whether it is proposal has been given, and if it is given, what is the outcome? This was not yet.
So if that ban is still in force, then you have no case.
I have no matters, my lord. Until as that ban is not lifted, my lord.
Yes, because naturally.
Yes, my lord.
On prey made by the United CGC, list is matter after 2 weeks.
This is another item was there, item number 10.
No objection, Your Lordship.
On prey made by the United CGC, list is matter after 3 weeks.
Your Lordship, I'd like to mention item number 3 and item number 9, Your Lordship.
You are for?
Your Lordship, I'm for the petitioner. I'm appearing on behalf of Philemon Nombri, Your Honor.
This is an old matter.
Your Lordship, senior counsel is not in station, Your Lordship. Kindly grant us some time.
How long?
2 weeks, Your Lordship. 2 weeks.
See, this matter has to be disposed of. Has the matter been heard?
Your Honor, I'm not aware at this junction, Your Honor. The brief is not with me. But I've been instructed by my senior counsel to kindly mention the matter, Your Honor.
You see, when you mention a matter, you have to be well versed with the subject matter.
Lordship.
Court may ask a query, and if you are not able to answer, then it's pointless of you standing and making submission on behalf of a party. It would do well for you to keep that in mind.
Apologies, Lordship.
On prey made by the petitioner, this is matter of 2 weeks.
Item 3 and item 9, Your Honor.
Here you are for
Petitioner.
petitioner. Who's for the respondent? State?
Lordship, I'm for item number 9.
You're for 9. You're for state?
On behalf of Miss Panchali.
Oh, sorry. On prey made by the Provident Fund. On prey made by the petitioner, this is matter after 2 weeks.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 7. So kindly list this matter on 21st of this month, Your Lordship, because the conducting counsel, he is from Karti. He said the other matter was listed in the Honorable Court of Justice Thanke. It was listed on 21st, so kindly list this matter on the same date, Your Honor, so Your Lordship, so he can come.
On prey made by the respondent, not objected to by petitioner, this is matter on 21st.
Please, Your Lordship. Lordship, I beg to make a mention in item number 11. Lordship, I'm praying for some accommodation, Your Lordship, since Mr. Paul is out of station, Your Lordship.
No objection.
On prey made by the appellant, this is matter after 3 weeks.
Highly obliged, Your Lordship.
Lordship, may I be permitted to make a mention of item number 12? On the last occasion, we were directed to submit written arguments. I seek for more time.
You're for?
I'm for the respondent state.
I'm for the appellant, Your Lordship.
Have you filed your written argument?
It's a joint prayer, Your Lordship. I need further 1 week time to file my written argument, Your Lordship.
On pre-made by the parties, this is matter of the 2 weeks.
Obliged.
Highly obliged.
Lordship, I beg to mention item number 13.
Well, I'm for the petitioner here, my lord. How long do you...
Lordship, 2 weeks.
My lord, the difficulty here is that, my lord, the trial court, the matter is fixed on the 26th. It can be adjourned only for a week, my lord. Next week we can do the hearing because the matter has not been stayed.
Okay. So next week,
Next week I'm okay with next week, but 2 weeks will be difficult.
so we'll see how it goes. On pre-made by the respondent, not objected to by petitioner, this is matter of the 1 week.
Much obliged.
Obliged, Lordship.
Excuse me.
Item number 2.
May I please the lordship? My lord, here, before I go to the case, my lord, the brief fact of the case is this, my lord. A complaint was lodged before the Lokayukt under section 20 of the Lokayukt Act, my lord, against 3 individuals. These individuals are not before my lord, my lord. We are the ex-MDCs of the district council, my lord. The complaint was lodged, preliminary investigation was conducted, my lord. Then, my lord, a CBI inquiry, the Lokayukt directed a CBI inquiry, my lord. That was challenged, my lord, by one of the accused therein, my lord, and that was set aside by the Honorable Court, my lord, Honorable High Court, and then the matter was remanded back, my lord. Then, my lord, after the matter was remanded back, my lord, they have conducted a fresh inquiry, my lord, and then, my lord, our name figure out, my lord, and the Lokayukt has directed that we should be prosecuted without hearing us, my lord. There is no complaint against of us, there was no charge against of us, and we don't know what is the charge even, my lord. Lokayukt has directed to prosecute us, my lord. My lord, may kindly come to Annexure 1, page 41, my lord. This is the act, my lord, on 27th March 2014, page 41, my lord.
Yes.
This is the act which was official. It was published in the official gazette notification, my lord, on 27 March 2014, my lord. Now, complaints are lodged, my lord, under section 20, that is on page 54. Chapter 7, page 54, my lord.
Yes.
If I am permitted to read, my lord. Section 20, clause 1. The Lokayukt shall, on receipt of a complaint, first decide whether to proceed in the matter or close the same, and if the Lokayukt decide to proceed further, it shall order the preliminary inquiry against any public servant by its inquiry wings or any agency to ascertain whether this exists a prima facie case for proceeding in the matter, my lord. Now, my lord, there was a prima facie case against those 3 people. Inquiry was conducted, my lord. Lokayukt has initiated a preliminary inquiry by one of the SDPO of Garo Hills, my lord. Then, my lord, what happened? During the pendency of the inquiry, my lord, they have approached this honorable court and set aside the order of the Lokayukt by which CBI was supposed to conduct an inquiry, my lord. If that is the case, my lord, when a preliminary inquiry is initiated and my name doesn't figure out, my lord, inquiry report was submitted and CBI inquiry was directed. Then, my lord, that CBI inquiry was set aside by this honorable court because the provision of the act itself was not followed by the Lokayukt. During the pendency of that case, my lord, they have amended the clause in the Lokayukt Act, and then only 1 chairperson was appointed, my lord. Earlier, it was 3 chairperson who should consider the preliminary inquiry report, and then they have to initiate a proceeding against the accused person if there is a prima facie case. So, there was no 3 chairperson appointed by the state, there was only 1, my lord. So, subsequently, they have amended the act itself. Now, my lord, may kindly see section 21, page 56.
Yes.
If at any stage of the proceeding the lokayak consider it is necessary to inquire into the conduct of any other person than the accused. So we are the other person, my lord. And clause B says, is of the opinion that the repetition of a person other than the accused is likely to be prejudice affected by the preliminary inquiry. Then, my lord, there are two clauses. Then what will happen, my lord? The lokayak shall give to a person a reasonable opportunity of being heard in the preliminary inquiry and to proceed evidence in their defense, produce the evidence in their defense consistent with the principle of natural justice, my lord. Now, my lord, that was not followed. My lord, may kindly come to the impugn order, page 81, Annexure 7. Before I take my lord to page 81, I would like to take my lord to page 80. That is also very relevant, my lord. Now, page 80 says this is an order which was passed on 10/5/2023, my lord. Seen prayer of the IO to extend the date for submission of the investigation report, as statement of some public servants could not be completed. Prayer allowed, IO is to submit the investigation report as early as possible, but not later than 19/5/2023, my lord. Now, my lord, may kindly come to the impugn order, the next page, page 81.
Yes.
Order dated 18/5/2023. The matter was fixed on 19, my lord. But on 18, my lord, this order was passed.
Oh, it says not later.
My lord?
It says not later than 19.
Yeah, but the matter was fixed on
Could be
19.
earlier also.
No, no. What I am insisting is on this, my lord. This says that before 19 you submit. The matter was fixed on 19, my lord. My lord, may kindly see. The matter was fixed on 19. 19/5/2023.
It is not fixed 19.
That is not the point, but I'm just highlighting, my lord. That is not the point. My lord, may kindly come to the impugn order, my lord. Case record put up today along with the investigation report submitted by so and so, the investigating officer.
Yes.
The following public servant are charged sheeted under section 7 and 12 of the Prevention of Corruption Act 1988. Now we are, my lord, 1 to 9, my lord. The rest are 1 to 9. The rest are those accused persons, my lord. Now, my lord, the director of prosecutions will submit the case record to the public prosecutor of the West Garo Hills, Tura, to initiate prosecution in a special court of West Garo Hills, Tura, my lord. So this is the impugn order, my lord. But the law says, my lord, that if a fresh name come out or a co-accused name come out, my lord, then under section 21, my lord, they have to give me a chance to adduce an evidence. They have never given me, my lord. That's why I am before this honorable court, my lord.
Well, who's appearing for
My
response?
lord, here what happened, my lord, there is no standing counsel. Mr. Sandeep Jindal used to appear for the Lokayu. We approached one of his junior, my lord. He said that they are not appearing anymore for the Lokayu.
We'll take steps then.
We'll take steps. On the meantime, my lord, only kept in evidence, my lord, this order. I will pray for evidence, my lord, because the law itself is very clear, my lord.
It is just an order for you to be charged sheeted. You have not yet been charged sheeted.
No, my lord, here the case is this, my lord. Lokayu already convicted me without hearing me.
No, here, look at the impugn order.
No, this is
This
one of
charge
the
sheet has
order.
been filed against you.
No, my lord, charge sheet will be filed in the special court. Once the Lokayu find that there is a prima facie case against of me and convict me, then only the file will go to the special court, my lord, to follow the criminal law, my lord. But here, my lord, Lokayu, section 21, he has to comply with, my lord. Section 21 was never complied by him. So only, my lord, my prayer will be, my lord, till the next returnable date, let this order be kept in evidence, my lord. We have filed a miscase also, my lord, a separate miscase.
Heard Mr. S.D. Leonard, counsel appearing for the petitioner. The petitioners being aggrieved by
The order dated 18/5/2023, my lord. Page 81, Annexure 7.
An order dated 18/5/2023
23, my lord.
passed by the Meghalaya Lok Ayukta, which is a direction to the concerned police authority to proceed against the petitioners.
No, my lord, it is, my lord. PP, my lord. Public prosecutor. The last line, my lord.
Untuk PP to proceed against the petitioners herein under the relevant provision of the Prevention of Corruption Act 1988.
88, my lord.
1988. The petitioner has approached this court with a prayer for setting aside the said impugn order. Mr. Day has also submitted that the impugn order has been passed without following due procedure,
And also the violation of principle of natural justice, my lord.
and also violation of principle of natural justice, inasmuch as
Section 21 was not complied.
Section 21B. Is it B?
It is A, my lord. A, read with
Page-
B, my lord.
page?
Page 56, my lord. 21, my lord.
Section 21 is B here.
Yeah, it is 21, my lord. There is two seen, my lord.
You are referring to this B where you have not been given the
Yes.
opportunity to be heard.
Yes, my
Isn't
lord.
it?
Yes,
So
my
that's B.
Yes, my lord. B.
Where is A?
A is just above of B, my lord.
A is above B.
A and then B.
Uno to go. Section 21. Section 21 of the what is the full form of the act?
Meghalaya Lokayukt Act 2014, my lord.
Provision of the Meghalaya Lok Ayukta Act 2014.
2014.
Inasmuch as the petitioners were not given any opportunity of being heard before proceeding was initiated against them.
And we was not a party also, my lord, to the proceeding.
Of course, that you can argue. Before launching to the merits of the case, the legal counsel has stated that the respondent may be put to notice, for which prayer for issue of notice upon the said respondent be allowed. Accordingly, that notice be issued upon the respondent, the same returnable within 2 weeks.
On the meantime, my lord, let this order be kept in evidence, my lord.
Can you come this case? Heard Mr. SD, legal counsel for the petitioners, for the legal counsel for the applicants. Prayer has been made for stay, for an interim stay of the order dated
18/5/2023,
18/5/2023,
23, passed in complaint case number 1 of 2019.
passed by the Leonard Meghalaya Lokayukta in complaint case number
1 of 2019.
1 of 2019.
19.
The ground set out by the Leonard Counsel for the applicant is that the impugned order was passed without affording any opportunity of hearing and for a blatant violation of the natural principle, principle of natural justice,
And section 21 of the Act.
particularly as regard the provision of section 21 of the said Lok Act of 2014. It is also noticed that the respondents herein have not been informed about the present proceedings. Accordingly, the petitioner, as has been directed in the main case, will ensure that notice is duly issued upon the respondents. In the meantime, the impugned order is hereby kept in abeyance until the next date fix.
Hello.
This is matter for 2 weeks.
Hello.
Item number 5.
This matter, Lordship, I pray for some time, Lordship, to file the written argument. Mr. Bora.
Mr. Bora, having a nap.
I filed the written argument. Actually, I was dozing off almost.
Yes,
But there is one drawback, my lord. Annexure 1 of the argument where the letter was sent to the project coordinator. Last page has been missing. I have called the villagers. If they have, I've given copies, so they will be coming tomorrow. In my office, I couldn't find the last page. That is, it has been filed with the 3 pages only. That is on the first annexure.
What is this an authority?
That is the authority under the Act. Under section 14 and 19, I had filed this application to the Deputy Commissioner as the project coordinator.
No, but
thereafter, we had come to the High Court.
But are these relevant? Are these the papers that you are referring to? Are these annexed to the petition?
No, not.
Then
it came during the hearing. It came. I had not annexed. That is why I have put it in.
But then can you introduce new facts at this stage? Because the argument would be only based on the basis of your
case, this material can be excluded from the argument.
Because
I don't have. I did not annex it with the petition.
Yes. Had
yes,
had it been the case of
yes,
you want this to be taken cognizance of, then you could have filed an application.
So this material may be excluded from the.
You take back your argument and just
remove this one.
Remove this.
Yes.
On premier by the parties.
3 weeks.
1 week.
Yes, ma'am.
2 weeks, Lordship. 2 weeks.
Yes, ma'am.
Please do it.
It'll be 2 weeks, Lordship. I'll file.
This is matter to 2 weeks.
2 weeks, Lordship. Obliged, Lordship.
So, Mr. Bora, I'll just take it out. And so that I will not, I don't no need to pass an order on this. This is a written argument.
Item number 8.
So where were we?
May it please your lordship. Your lordship, I am for the petitioner in this case, your lordship. Your lordship, what happened in this case? Prior to my appointment, respondent number 6 was serving as an assistant teacher, your lordship. His convictions to one of the criminal cases lead to termination, your lordship, where the post was laid vacant, and my name has been recommended by the managing committee for the approval, your lordship.
Okay.
If I may take your lordships to Annexure 1, your lordship.
Just Annexure?
Annexure 1, page 15, your lordship. The type copy is a translated copy is at page 16, your lordship. Translated copy is at page 16, your lordship. Here the managing committee has taken a resolutions and my name has been recommended for the appointment of assistant teacher, your lordship. If I may allow to read.
This was in the in the intervening period when the incumbent was suspended.
Yes, your lordship.
He was suspended or
terminated, your
terminated.
lordship. Terminated, your lordship. As to his convictions to one of the criminal case under section 302, your lordship, by the learned trial court. So my name, the managing committee has taken the resolutions. My name has been recommended for the assistant teacher, which the post is land vacant, your lordship. This resolution is the page number 16, your lordship. If I may allow to read, your lordship.
Yes.
Yes, your lordship. As per the directions from the office of the deputy inspector of his school, Mairang, by letter so and so, dated so and so, has held a managing committee, Nongliar LP School, on the so and so date to discuss the matter relating to the conviction of Shri so and so, that is respondent number 6, your lordship. And a decision was taken which was agreed as follows. Number 1, to urgently appoint Shri Ibing Star Molang, that is petitioner, your lordship, before your lordship. Class so and so passed in place of Shri so and so that the student won't suffer. Shri Ibing Star Molang earlier had served the school since the year 2004 because of the heavy workload faced by Shri so and so, and until now he is the one who is willing to help the school because of the conviction of Shri so and so. This matter is handed over to the chairman to give the appointment letter to Shri so and so and to ask the approval and confirmations from the deputy inspector of school, Mairang. As directed from the deputy inspector of Shillong, Mairang, the managing committee has terminated Shri so and so upon his convictions on 28/7/2010. This is the date where the learned trial court has convicted the respondent number 6, your lordship. The matter has handed to the chairman to do the needful, that is to give the termination order to Shri so and so from that date. Number 3, since Shri Dwick Lindo was terminated from his service, who was also the secretary managing committee, therefore the managing committee has selected the members of the managing committee, which are as follows. The name of the managing members not need to be required, read, your lordship, not need to be required to read, your lordship. As the resolution, your lordships, the managing committee has wrote a letter to the deputy inspector, that is at page annexure 2, your lordship. Page 17. Type copy, it is at page 18, your lordship. Sorry, translated copy, your lordship.
Yes.
If I may allow to read, your lordship. As per the decision of the managing committee, Nongliar LP School, which was held on 7 September 2010 on the basis of the letter so and so, dated so and so, from the deputy inspector of his school, Mairang, Sri Dwick Lindo, teacher of Nongliar LP School, has been terminated from service since 28/9/2010 with regard to the case so and so under section so and so. This removing of service of Sri so and so have done as per the instructions of the managing committee and the authority from the state government to give their approval and confirmations regarding this matter. Accordingly, this letter was sent to the deputy inspector, your lordship. Now, if I take your lordships to annexure 3, where the termination of respondent number 6 has been approved by the state respondent, your lordship. That is annexure 3, page 19, your lordship.
Yes. This respondent 6, huh?
Respondent number 6, Your Lordship.
His termination approved.
Termination, the respondent state, Your Lordship, has approved the termination of the respondent number 6, Your Lordship.
Yes.
If I may read, Your Lordship. The termination made by the Managing Committee Nongler LP School Wide Order so and so in respect of Sri so and so LP School is hereby approved with effect from the date of final judgment order dated so and so from the Fast Track Court East Kashmir District Shillong in connection with case number so and so under section so and so. That is the approval order of the termination of respondent number 6. Now, Your Lordship can kindly come to Annexure 4, where my appointment has been approved by the state respondent as an assistant teacher, Your Lordship. The Annexure 4, page 20, Your Lordship.
Yes. Yes.
May I please to read, Your Lordship. The appointment made by the Managing Committee Nongler LP School Wide Order so and so in respect of Sri Iving Star Molong class so and so passed at Nongler is hereby approved with effect from the date of joining in the scale pay of so and so. I kindly pray Your Lordship can kindly note down this scale pay, Your Lordship. Scale pay which I was withdrawing as it's of a permanent teacher, Your Lordship. Plus other allowances at admissible under the deficit rules. Vice Shri so and so terminated, Your Lordship. So my appointment has been approved. After my appointment, Your Lordship, I served for 7 years, Your Lordship, without any without any interventions from any sources, Your Lordship. I have been served for 7 years, Your Lordship. So one finally, Your Lordship, to my utter shock and surprise, my job has been terminated, Your Lordship, without giving me any show cause notice, Your Lordship. No opportunity has been given to me, Your Lordships. And Mr. Respondent number 6, who was acquitted by the Supreme Court, has been appointed again. He was reappointed, Your Lordship. He has been reinstated in the service. If may I take Your Lordships to Annexure number 5, Your Lordship. Page 21, Your Lordship.
Yes.
If I may allow to read, Your Lordship. The appointment made by the Managing Committee, Nongler LP School Wide Order, that is so and so, to reinstate into service of Sri Dwik Lindo, assistant teacher at Nongler LP School, is hereby approved with effect from the date of joining in the scale pay of so and so, plus other allowances as admissible under the deficit rules. The appointment will remain in force till further order. The service of Iving Star Molong has then terminated with effect from the date of joining of Sri Dwik Lindo, Your Lordship. Now, my termination, Your Lordship, is totally illegal and arbitrary, as it is a violation of natural justice, Your Lordships. No opportunity has been given to me, and no show cause has been given to me, Your Lordships. That, Your Lordships, the way back in 1978, Your Lordships, the Constitution Bench of the Honorable Apex Court has held that the violation, the natural justice is a fundamental right, Your Lordships. In Maneka Gandhi versus Union of India, where the petitioner passport was impounded by the authorities, Your Lordship, where the petitioner passport was impounded by the government of India in public interest, Your Lordship, without affording any opportunity of hearing to the petitioner before taking the impugn action. Therefore, the Apex Court held that the order taken by the state authority is totally illegal, is totally violations of the principle of natural justice, Your Lordships. The same has happened to me, Your Lordships. This judgment still hold the field still dead, Your Lordship. Now, Your Lordships, if Your Lordships, that if the statute provides the rules that the respondent has to act under the certain way, then they have to act as per the rules provided under the code, Your Lordships. If may I take Your Lordships to the Meghalaya Education Code, Your Lordship.
Yes.
May I take Your Lordships to page 170?
Yes.
Rule 5, sub rule 1, that is page number 171, Your Lordship.
Rule 5.
Rule 5, sub rule 1, Your Lordship. Page 171.
Dismissal or removal.
None of these penalties shall be imposed on an employee of an added school until he has been given a reasonable opportunity. That is page 171, Your Lordship.
Rule 5.
Rule 5, yes, Your Lord. Rule
Any
5.
of the following penalties? Oh.
Yes, Your Lordship.
You are referring to the proviso?
Proviso 1, Your Lordship.
Yes. Please.
If I may read, Your Lordship. None of these penalties shall be imposed on an employee of an added school until he has been given a reasonable opportunity of showing cause against the action proposed to be taken in regard to him, Your Lordship. This is the specifically laid down, Your Lordships, that if the action has been taken against the petitioner, show cause notice may be issued to them, where they have slurped the rules, Your Lordship, and they have taken the decisions which is totally arbitrarily and illegal, Your Lordships. They cannot act as per their whims and fancies, Your Lordships, when the rules provide that specific rules has to be followed, Your Lordships. The gross negligence, gross injustice has been done to the petitioner here, Your Lordships. Now, Your Lordship, during the pendency of the matter, there are certain developments. The respondent number 6 has attained the age of superannuation, has been retired from the service. Now, Your Lordship, the school managing committee has appointed respondent number 7 during the pendency of the writ petition, Your Lordship. Now, if I take Your Lordships to
when the writ was admitted,
yes,
any interim order?
No, Your Lordship.
No stay.
No stay, Your Lordship. Your Lordships can kindly come to affidavit filed by respondent number 5, Your Lordship. The appointment of respondent number 7, Your Lordship, it's totally
page
affidavit of respondent number 5, page number 8, Your Lordship, annexure D.
Just this one. Para?
It's an advertisement, Your Lordship.
No, you're...
I'm referring to affidavit filed by respondent number 5, Your Lordship.
Okay. Annexure?
Annexure D, Your Lordship, page number 8, Your Lordship.
Okay. Yes.
Your Lordship, during the pendency of this writ petition, respondent number 6 was attained the age of superannuation. He has retired from the service. Respondent number 7, who has been implemented subsequently during the pendency of the writ petition, has been appointed, Your Lordship, just to deprive the petitioner to reinstate in his service, Your Lordships. May I take Your Lordship, that's the advertisement, Your Lordship. This advertisement is a handwritten, Your Lordship. This has never been published in the newspaper, Your Lordship. Your Lordship must be very much aware that if the vacancy is stand in any department, then the vacancy should be published in the newspaper for the information of the general public, Your Lordship. Here, this advertisement has not been published in the newspaper, Your Lordships.
Annexure D.
Annexure D, Your Lordship. Affidavit filed by respondent number 5, Your Lordship. Now, if I read your lordships this advertisement, applications are invited for the post of assistant teacher at Nongler LP School under deficit system of pay minimum so and so with 45% above so and graduate with 45. Applications form will be received with effect from 1 November 2018 to 2018 at the office of the managing committee at Nongler School. Time 11 a.m. to 3 p.m. Date of personal interview will be held on 26 November 2018. The school building application must be right clearly there. Phone intimations. This is the advertisement, your lordship. Now, your lordship, they have not meant this as per your lordship, my little knowledge and my little knowledge, your lordships, it clearly shows that the advertisement is for the regular post. The teacher who has been appointed need to be appointed as a regular teacher. Now, what they did, your lordship? If your lordships can kindly come to affidavit filed by respondent number 7, your lordship.
Who is respondent number 7?
Respondent number 7, who has been appointed during the pendency of the writ petition, your lordship.
Or respondent, yes. So respondent 7 is the present incumbent.
Yes, your lordship. Present incumbent, your lordship.
Yes.
Now, if I take your lordships to Annexure 1, page 7 of this affidavit, your lordship.
Yes.
I'll just take to the second paragraph, your lordship. That will serve my purpose, your lordship.
Yes.
The appointment is purely temporary and may be instant cancel termination after the expiry of 59 days, your lordship.
Okay.
Whereas the advertisement clearly shows that the advertisement was for the regular post, whereas in pursuance to that advertisement, a temporary teacher has been appointed, your lordship.
Yes.
And the advertisement has just been published without publishing in the newspaper, just hanged in the school premises just to accommodate respondent number 7, your lordship, and nothing else, your lordship. This is the highly illegal and arbitrary act of the state of the respondent, your lordships, which need to be set aside, your lordships. And the petitioner is, I humbly pray the petitioner may be reinstated in his service, your lordships. Whereas the respondent number 7 appointment has not been approved till date, your lordship, as it is in temporary in nature. It has a status of temporary in nature, your lordships. That only for 59 days, that has been renewed to another 59 days, your lordships. So for them, this is not under challenge before your lordship because they have not attained the approval of the state respondent, your lordship. And moreover, it has a status of temporary appointment that can be terminated without giving any show cause notice, your lordships. The appointment of respondent number 7 is highly illegal and arbitrary, your lordship.
So the appointment has not been approved by government?
No, your lordship.
But this order says so?
No, that appointment means, when I talk about the approval of the appointment, regular appointment, your lordship.
Regular.
It's a temporary appointment, your lordship.
This is temporary appointment.
Yes, your lordship. So I humbly pray that the petitioner may be reinstated into his service, your lordship.
Yes.
May please, your lordship. Your lordship, I am appearing on behalf of respondent number 1, 2 and 1 to 4, my lord. The government, my lord. My lord, going through the record, my lord, it is very much evident and clear that the writ petitioner herein was initially accommodated on account of a criminal case pending against Sri Duik Lingdo, because of which he was convicted and he could not have been retained in service, my lord. This vacancy arose, and during those vacancy period, my lord, as a stopgap arrangement, my lord, the managing committee has forwarded the name for the petitioner's approval, my lord, to the government. So that was the initial ground of giving the right to the petitioner, my lord. So what has happened, my lord? Subsequently, this Duke Lindo, my lord, as per it is his legal right to go for appeal, and on appeal the conviction was set aside. Subsequently, his conviction being set aside, he was accordingly also reinstated back to service. So what happens is that, my lord, the writ petitioner, he was holding this post so long the Duke Lindo, who was the accused, was not reinstated. So he did not acquire any fresh vested right in the post, my lord. The moment
in his appointment order.
Yes, my lord.
Are those terms and conditions specifically mentioned?
No, my lord. This was a stopgap arrangement done by the managing committee so that the students do not suffer.
Whatever the case may be.
Yes, my lord.
It could be stopgap, it could be permanent, it could be temporary, whatever.
Yes, my lord.
But once you have given an appointment to a person, and considering the fact that you are contemplating that it is a stopgap arrangement, there must be conditions for it.
My lord.
Your appointment is temporary only with regard to the vacancy caused by so and so.
So and so, yes, my lord.
And in case so and so and so comes back.
No, that condition was not given. Even at the time of appointment of the writ petitioner, that condition was not laid down. So that is because it was totally the prerogative of the managing committee.
Whatever the case may be, you know very well. See, settled law is this: once a person has been appointed, he has been clothed with a vested right.
My lord, if you come by the back door, you go by the back door. And here is a case, what happens is that...
He has not come by the back door, it is you. Not you rather, it's the managing
committee. No, here the writ petitioner did not apply for it through any advertisement. Whereas the present incumbent, because after this writ petitioner was holding and the reinstatement came into being, he was automatically removed from service. Then this Duke Lindo continued in service and retired, my lord. On his retirement, the post became vacant. The managing committee thereafter took a decision for advertising, my lord. Whether he questions the mode of advertisement, that is definitely his right to question. The public can do what they have done. The minimum, instead of spending lot of money in advertisement, internet and all, they must have done and displayed in the notice board, and a shortcut method was adopted. It appears
that cannot be allowed.
No, that cannot be allowed. But then it has been done. It is not that the advertisement was not done. Advertisement, even in the DC office, some notice and all are displayed. This is a general practice which has been done from time to time, my lord. Of course, sometimes it is required that if the managing committee had they been well equipped, they could have sent to the newspapers for other participation. And in times, my lord, it also happens that they want teachers from the same locality. So they might not even give to the newspaper. Even if they give to the newspaper, they will add one more clause, is that people from and within the area will be preferred. Even if it is given wide circulation, my lord, in order to ensure that the teacher do not miss to attend or take classes, my lord, they might be given this stipulation that students or candidates should be coming within these areas and they will be preferred. So that was not done. Here a shortcut method was adopted.
You produced before the court, produced before this court the law with regard to advertisement.
The law to the advertisement.
Any precedent, any principle set out? No. There must be authorities on this.
I'll try on this. What is the correct mode of advertisement and all? Because Umadevi's judgment also did not clearly specify that what should be the correct mode of advertisement. Only thing what we have read from judgments is that if you come by the back door, you go by the back door.
That is
what they mean to say, that if there is no other participation.
That is too general a term.
So, my lord, I'll try to find a law on that. And what happened is that the present incumbent who participated in the advertisement proceeding, and the managing committee found them fit, has sent the approval, has appointed and sent the same thing for approval by the government.
How many? Okay, let me ask the managing committee.
Yes,
please continue.
So what happened is that, my lord, the moment Duke Lindo was reinstated, automatically his service ended, my lord. Automatically his service ended. Now, after his advertisement, after his service has ended, and he continued in service, so long he was in service, the writ petitioner did not have any cause of action. Why you have to reinstate him? He should have challenged even the reinstatement, because the Dui Klingdo has his vested right to the post because he was a regular employee to the regular post. And because of a criminal case, fortunately or unfortunately against him, he was terminated from service, and the moment he got an acquittal from the court, his right restored back and he was reinstated. And thereafter he even completed his complete service tenure, my lord. And after completion of his service tenure, my lord, he retired, and upon his retirement, the post felt vacant. So what the managing committee did was advertise it. So advertisement, against the advertisement, the writ petitioners saying that since I had worked for last 7 years and I was not rewarded by giving the post to me automatically, they call for an advertisement, and now they are challenging the present incumbent. Present incumbent has a genuine vested legitimate expectation and a right, which he or she must have participated through the selection process, and they have come forward. I am not trying to justify in any manner, but then the writ petitioner's right ended the day Dui Klingdo has been reinstated, my lord. Because that is an law of service law, is that the moment he is reinstated, the temporary arrangement is taken away, my lord. And he completed his service after being reinstated, and upon his retirement, the post became vacant, my lord. And the vacancy was filled up through an advertisement. So I don't see there is any illegality till this point, my lord. And if at all there is anything, he should have participated in the advertisement. He never participated, even in the entire writ petition. We never came across what is his qualification.
Because
why did the managing committee?
He could not have participated in the selection because the advertisement itself, has stipulated certain qualification marks. He is not qualified.
So if he is not qualified, law cannot help if he cannot qualify the requirements. Yes, it cannot be made tailor-made for the writ petitioner, my lord. It was in that context that the managing committee found someone else fit for the post and recommended the name for approval, my lord. So I believe, my lord, that third-party right has been also in existence, which you cannot just simply throw away because he has come through a regular advertisement, my lord. So what I am saying is that the writ petitioner the present writ petition is a total misconception of law, my lord. This is not a fit case to invoke the writ jurisdiction, because the day Dui Klingdo was reinstated, the service of the writ petitioners has ended, my lord. And he cannot challenge it. He cannot challenge it by way of writ petition saying that I need to be heard. Your appointment was subject to the vacancy cost because of the criminal case and the suspension and termination of Dui Klingdo, my lord. And Dui Klingdo, he has, insofar as his job is service career is concerned, he has completed his service. He is very happy. He has retired. So he is gone happy, and now because the post fell vacant and the post was subsequently filled up by a new incumbent, my lord, and the new incumbent, after passing through the selection process, this is not the right mode of giving appointments just because of your previous service to the institution. You cannot be given a vested right to say that the new incumbent should be thrown away and I should be preferred to the post. That is entirely the discretion of the managing committee, my lord. Even if any post falls vacant for any matter, my lord, the process will be adopted the same. So, my lord, I say that the writ petition is not deserve any attention, my lord, and it should be dismissed, my lord. And we should also keep in mind the third party right which has been created, my lord. Whatever be the period of time, the period of time cannot be ignored, my lord, because the present incumbent has entered into service through a legal means, not through a back door, or not without any participation in the advertisement. Whether the advertisement was given in a newspaper or in a notice board, but advertisement was given and he participated in the advertisement. Whether what marks was given, we do not know. It has not been put to challenge. So I believe, my lord, the writ petition does not deserve any entertainment and it should be dismissed, my lord. So that in the interest of justice, the incumbent who is already there, without disturbing the school curriculum, my lord, should be dismissed, my lord. That's all, my lord.
So who is for?
Managing committee. I'm respondent 5.
You are the managing committee? Yes. And respondent 7? Okay. Yes, Mr. Wala, tell me. We'll hear it. Then you can reply.
Yes, Your
May it please your lordship.
Yes.
I'd like to draw your kind attention, your lordship. Annex 3 of the main petition, the writ petition, Annexes 3, this is page 17, no?
Page 19.
Page 19, your lordship. Again, I'd like to draw your kind attention.
Yes.
Yeah. Just to show one of the details, your lordship. The termination so and so, white order so and so is hereby approved. That's from the is hereby approved with reference from final judgment so and so from the fast track in connection with so and so. This order will remain in force until further orders. Means it doesn't mean it is regular. It is just at any time the respondents, I mean the government, I'm talking about the department, has got every right to change it because he has already subscribed his signature to that. This order will remain in force, means at any time, Your Honor, which is, can we call it, kind of a temporary, we'll call it a temporary matter, Your Honor. But which is important, Your Lordship, I'd like to draw your kind attention, Annex 4, which is very important, Your Honor.
Yes.
Yes. I'm talking about the writ petitioner, Your Honor.
Yes.
Why the appointment made by the MC,
Yes.
Nongal Air LP School, white orders so and so, in respect of the writ petitioner I'm talking about, Your Honor.
Yes.
He is also his class is only class 12, Your Honor. Class 12. As only reflected in the writ petition also, Your Honor. Pay scale, and again I'll come back to that. The appointment will remain in force until further orders. Or we call it is just a mere kind of a stopgap for the interest of the school and for the children. I mean for the students, Your Honor. Which is important, Your Honor, Your Lordship. I had already filed one application, missions application. I've already filed just to bring on record, I mean by way of affidavit, Your Lordship. This order, the order passed by this Honorable Court, white order dated 9/12/2020.
Where is that?
Yes. I'll draw to your kind attention in the business application, Your Honor.
Yes, okay.
The course title is mentioned affidavit filed by respondent number 5 to bring on record the government notification. That is very important, Your Honor. Dated 9.
Yes, sir.
Yes, Your Honor.
You filed an affidavit?
Yes, Your Honor. At that time, I think it was in the court number 2, Your Lordship. This has been filed, Your Honor, Your Lordship. Right from 2021, Your Lordship.
It's not here. Show me a copy of the order.
Neither it's in my record, Your Lordship.
Huh?
Neither it's in my record, Your Lordship.
But it was mentioned in the year 2020.
Show me a copy of that.
Yes, Your Lord. This is the only copy I have. Yeah, the notification issued by the government respondents, Your Lordship.
It is not here, Mr. Malan.
In fact, even that order passed by this Honorable Court, Your Lordship.
Just one, let me just check again.
Yeah, that was in the year 2020. I don't have with me the order of that.
It should be here. If your file means it has to be on record.
As per the order passed by this Honorable Court.
And where is that order? So you have not referred to any order.
In one of my advertisement, I've already mentioned, Your Honor, Your Lordship, which para I think. In one of the
just one.
paras. Yeah.
Yes, by this order,
Yes, Your Lordship.
you have been allowed to
Yes, Your Lordship.
produce notification by way of
Yes,
an affidavit.
yes. That is the what, Your Lordship.
But this affidavit is not on record.
I think we have.
It has not been filed.
We'll, just in case, Your Lordship, in case if there's any mistake from our part, any omission or commission, Your Lordship, then allow me also to file as per that order by this Honorable Court again, Your Lordship.
At this point of time?
Because this is already the order passed by this Honorable Court.
Yeah,
Allowed,
that
already
order
allowed,
is
Your
there.
Lordship.
It has allowed you.
Yes.
But
or maybe
you have failed to do it.
There's an act of-
There's
there's an
nothing
act
on
of-
record.
Could be act of omission on the part of the.
2018
We'll not
matter
like
was
to, will not try to mislead this Honorable Court, Your Lordship. Needed to suppress. Because this notification, it has become effect right from 2015. Until now, it's still binding, Your Lordship, which is in fact in conformity with the Supreme Court ruling also, Your Lordship. As far as the eligibility conditions
That
of
is-
a teacher.
This is the
With your permission, Your Lordship. I'm sorry for the omission, Your Lordship.
where's Mr. Sengupta?
Yes. Yes.
Where is he?
I think nature's gone.
Is it written candidly, Your Lord, candidly, as far as the
No, what
notification
do
is
we do?
concerned?
This paper is supposed to be filed. It's not yet in.
I'm sorry. I think maybe I should. I mean, this is the order passed by. I'm not trying to mislead this Honorable
No,
Court, Your
that
Lordship.
is not the
Yes.
point. The point is, an order has been given. You have been allowed to. If you fail to do it, doesn't matter. If it doesn't hurt your case, then it doesn't matter. It's up to you. If you think that this particular
Yes, yes. Notification.
is relevant,
Yes.
you feel that it's relevant to your case, you bring it to notice of the court. But in the meantime, if you feel that it's not relevant,
no.
And as far as that speaks only about the qualification, that is easy. As of now, it is well settled.
Yes. That is very relevant in this writ petition, Your Lordship. And
Yes,
for the
Mr.
interest of justice also.
Mr. Sengupta, in your affidavit, have you stated anything with regard to the qualification?
No, my lord.
As to who is qualified to be appointed as teacher and this?
In the affidavit, my lord, of the other respondents which I have come across, my lord, they have pleaded the qualifications also, my lord.
Even in my affidavit reply, I mean, opposition, I specifically mentioned, paragraph 14, nothing to do with notification, but as far whether he is legible or not. My humble submission,
Yes,
with your
yes.
permission, Your Lordship.
Just a moment.
Let me just file again another missions application,
Why? If it is not, like I say, if it is not necessary, we should not waste time.
which is relevant to that, has got an impact on the case, Your Lordship.
Para 14, you have referred only to the
You would have
advertisement.
mentioned, yes. Which is in conformity with the government respondents, Your Lordship. For the post of teacher at LP school so and so, respondent so and so, and due to urgent, Your Lordship. I'm not talking about anything. Urgent requirement of the teacher for the interest of the school. The MC have informed the matter to respondent 4. Thereafter, for appointment of the new teacher. Prior to that, before giving the advertisement, we have already given the, if we have already approached.
You are reading what from?
Paragraph 14 of the affidavit
Paragraph
of
14.
page 4.
Yes.
Yes. Paragraph 14.
Yeah,
And
that
the
is
due process of the recruitment.
You have filed your reply to this
No, this is affidavit.
rejoinder. Have you filed any?
No,
rejoinder?
Your Lordship.
You have not filed any rejoinder.
Any rejoinder to this?
See.
If you have not filed any rejoinder, that means you have accepted.
Yes.
the position.
Acceded, Your Lord. Acceded, Your Lord. You have given before. This is affidavit is by us. So it is not.
Your Lordship, we have filed our reply to affidavit filed by respondent number 5, Your Lordship, that is in record.
So I asked you just now.
So
You
sorry,
said
Your
no.
Lordship, I was.
And your appointment is not a regular appointment.
No, Your Lord.
You are just appointed in the officiating capacity.
Yes, Your Lord.
So where is your right?
No, I'm the respondent 5, Your Lord.
Oh, sorry.
I'm the managing
Oh, you're
committee.
talking, sorry. I'm very sorry.
And, Your Lordship, prior to that, we have already approached the government's respondents also, Your Lordship, prior to the, before appointing the,
Yes,
I mean the impleaded respondent, Your Lordship, which already specifically mentioned in this my para 14. Even prior to that, I'd like to draw your kind attention. Even in para 10, page 3, Your Lordship, which I already specifically mentioned.
Just show me that notification again.
Oh, yes.
Your
Yes. This is the only one I have, Your Lord. This is in 2015. Their case is in 2018. No? Yes. Which is, oh yeah, thank you. With your permission, can I read before this Honorable Court, Your Lord?
read what?
And just to read this, I mean the notification, Your Lordship. With your permission.
Yes, sir, please, please.
Yes. From, talking about again, so and so Director of School Education, DSEL, Your Lordship, I mean in short, to District School Education, so and so, to different districts, Your Lordship. And then subordinate to that, to the district, means the subdivisional schools, which in fact, because I also, I mean the managing committee falls under this subdivisional school education. Subject, Your Lordship, very important. Appointment of LP/UP school teachers as per NCTE, Your Lordship. Norms. Sir, no, Your Lordship, I am to inform that since the NCTE norms came into effect from 23rd August 2010, where it has been specified that only those candidates who fulfills the NCTE norms should be considered, Your Lordship, should be considered for appointment as assistant teacher, either LP/UP school. In this case, Your Lordship, this is just an LP school, Your Lordship. LP school. For appointment in LP school, which is being mentioned in para 1, HSSLC pass with 45% and 2 years, Your Lordship, diploma in elementary education. This is a very important criteria, Your Lordship. Or B.Ed, or 4-year bachelor in elementary education, or we call it B.Ed. 2 years diploma in education. Again, Your Lordship, without going to the appointment of UP school, is the last para of this notification, Your Lordship, with the regard to the appointment of teachers, because mine is a non-government LP school, Your Lordship. That is a non-government /ad hoc or /deficit. You are instructed not to issue appointment but only approval order for those candidates who possess the above qualifications. Again, I come back to this in this case, Your Lordship. The writ petitioner doesn't have any locus standi, Your Lordship, by coming before this Honorable Court. In fact, I do have with me the citation, with your permission, Your Lordship, as far as the eligibility conditions, which is very much in conformity with the notification issued by the government respondents, Your Lordship. It has become into effective right from 2015 onwards, Your Lordship, as per the notification.
Do you have any objection to this communication?
Your Lordship, since the Planet Trial Court has given an opportunity to file this notification and they have failed to it, so I humbly pray that that cannot be taken into consideration at present, Your Lordship, because the hearing is almost concluded, Your Lordship.
Your Lordship, with this
But
Honorable Court knows.
even then, you see, when it comes to qualification, I think by now it is well settled.
Your Lordship,
as far as the norms are concerned.
if I may reply to this, Your Lordship, allow me to reply on this. Your Lordships, when I have been appointed, the managing committee is the authority to make an appointment as per the Meghalaya Education Code, Your Lordship. That has been forwarded to the state for the approval. Now, who is the scrutinizing authority, Your Lordship, of the documents? It's the managing committee. It's not me who has scrutinized my documents. After scrutinizing my documents, the managing committee has forwarded my name. Now they, at this stage, now they have no right to review my qualification, Your Lordship. Because they have already scrutinized my documents. I was not a backdoor appointee. My name has been recommended by the managing committee. They have scrutinized my documents. Accordingly, they have forwarded to the state government. State government, after scrutinizing the same, has approved my appointment, Your Lordships. So at this belated stage, they have no right to review my qualification, Your Lordship.
Your Lordship, my humble submission, whatever my learned counsel on behalf of the writ petitioner, this had come prior to 2015, the notification, Your Lordship. If I'd like again to draw your kind attention, Your Lordship, Annex 3 and 4 of the writ petition, Your Lordship, specifically mentioned 2010.
So this is prior, subsequent?
Yes, prior to that, Your Lordship.
Prior to what?
Because notification for, that we have is 2015,
2015.
which is prospective.
Yes.
Which is prospective.
And his appointment is 2010.
2010.
Then why should I suffer for the mistakes which has committed by the state government and
happened?
managing committee, Your Lordship?
Prior to 2015, this notification is not, it's not effective.
No, yes.
That's true, Your Lordship.
No, I'm not trying about to say that notification. The main point is that he is appointed as either at any time he may be terminated. He had already subscribed to that.
That is a different thing.
Which in fact I have a ruling for that also, if need be, Your Lordship,
that is a
with your
different
permission,
That is
on the
a
next
different
date. They've already admitted. I have been appointed on temporary basis. That means I have subscribed my signature, or rather I've already admitted.
That is a different thing.
That is another. With this Honorable Court news better for the citation passed by the
Of course.
Apex Court.
Yeah, all the parties are at liberty to file, to refer to any authority that you want to. Yes, anything else?
No, nothing. Except with your permission, let me file a small application.
I don't think it's too late in the day to come. We are already the second of the hearing.
It doesn't mean if I have not approached this Honorable Court, or there's no order passed by this Honorable Court, I would not come before this Honorable Court, Your Lordship. But it will specifically invite this order. That was in the year 2020.
By the very principle of delay and lashes,
yes.
you have forfeited your right. You have been given a direction way back in 2020.
No.
Now more than 2 years have passed. You have not done.
My humble submission for the interest of justice for all sides. I'm not talking just for my side, for the interest of all parties. That's my humble submission.
How old are you?
Me, I'm 36, Your Lordship.
36. So you still have a long time for your service.
I make pardon, Your Lordship, the petitioner age, Your Lordship.
I'm addressing you.
I'm so sorry, Your Lordship.
Oh, you are the same age with the petitioner?
What's your age affidavit? Just check.
And this is I have already
You will be 44, 45?
Yes, Your Lordship, because when the advertisement was published, I was not participated because I was overage as per the advertisement, Your Lordship. And I have given my good 7 years to the respondent, Your Lordship.
That of course.
And they have not adhered the rules laid down in Meghalaya Education Code, Your Lordship, which the Honorable Supreme Court also clearly says that when the rules provide need to be followed. And for that, if Your Lordships can kindly take two decisions.
Will I think see, there's a court order. Will allow him to file that affidavit.
Yes. Highly obliged.
But you do that only.
Yes.
I'll give you 1 week's time.
Yes, sir.
No further time.
Yes, yes.
If you fail to do it, you're forfeited. Or counsel for the petitioner, as well as the learned senior additional GA, Mr. S. Gupta, for the state respondent. However, in the midst of hearing of the respondent, hearing of the General Counsel for Respondent 5, oblique Managing Committee, the General Counsel has referred to an order dated. What's the order dated? Court order?
Yes, Your Lord. 9/12/2020, Your Lord.
Dated 9/12/2020, wherein this court has allowed the said respondent number 5 to produce a notification by way of an affidavit. The legal counsel has submitted that through inadvertence, the said affidavit has not been filed before this court. To the extent that non-filing of the said affidavit may be construed as an act of contempt, the learned counsel has submitted that he may be allowed to file the said affidavit. The learned counsel for the petitioner has strongly objected to the prayer, inasmuch as the same has been made very late in the day, when the matter has already reached the stage of final hearing. However, this court, on consideration of the prayer made and also to allow the parties to produce the best defense, the prayer of the learned counsel for the respondent 5 is allowed. Let the said affidavit be filed within the next date fixed. It is, however, made clear that should the said affidavit however made clear that if the said affidavit is not filed within the next date fixed, no further time will be allowed for filing of the same. In fact, before filing of such affidavit, the respondent 5 is directed to issue advance copy to the petitioner and or the respondent if so required, so as to allow the petitioner and other respondent to file their reply if so instructed. What you can do, file, give them an advance copy, and on the date you file, their reply will also be filed, so that will cut short the process. Otherwise, we have to wait for another 1 week, 2 weeks for that. So I allow you 2 weeks for that.
We'll comply with this, as per this honorable court.
As prayed for, list is matter to 2 weeks.
Highly obliged.
Highly obliged, Your Lordship.